Good evening, I'm Arunima. Just ahead of winter session of Parliament, there is more chill in the government-opposition equation. Congress's top leadership, Rahul and Sonia Gandhi, have been named in a fresh FIR in the National Herald case. Delhi Police EOW has lodged a fresh FIR after a reference from the Enforcement Directorate. BJP has called the new case more proof of corrupt Congress, while the grand old party has labelled the latest development a witch hunt. Why did ED seek a fresh FIR when it has already filed a prosecution complaint in their case? Is there new evidence to prosecute, or is it vendetta politics? The weekend explosive debate tonight.
मेरा मानना है, मैंने पहले भी आपके माध्यम से कहा है, ये एक चक्र चल रहा है वेंडेटा पॉलिटिक्स का।
आईएनसी का मतलब इंडियन नेशनल कांग्रेस नहीं, आई नीड चोरी, आई नीड करप्शन बन चुका है।
1 crore to young Indians was then used to acquire AJL without by paying 50 lakhs to the Congress party. All of this raises serious questions.
Vendetta charge, or is it proof of graft? To discuss that on the show tonight, Shahzad Poonawala, national spokesperson of the Bharatiya Janata Party, is with us. I'm hoping Kapil Madan, advocate and political analyst, will also be here to give us the perspective from the Congress's side. Ashish Dikshit, a legal expert, a lawyer in Supreme Court, I'm hoping he'll join us too in just a bit. But Shahzad, let me begin with you. This case was already probed by the Enforcement Directorate. Subramaniam Swamy made a private complaint. ED carried forward its investigation, reached a stage where even the charge sheet or the prosecution complaint was filed. After this entire process, when the order of the court on cognizance is awaited, ED goes and makes a reference to Delhi Police saying, please register an FIR on the same charges. Defense can turn around and say, what is the new evidence? If you have finished your investigation, filed a charge sheet, why a fresh FIR?
Let me answer this in two ways. First of all, the political answer, because everything stems from politics, and then the legal answer. As far as the political answer is concerned, here is a family that feels that it has the right to rule and the right to loot. And if they lose an election, they start blaming the election commission or the institutions. And if they get caught looting, then they start blaming any institution or agency under the court of law which has been given a mandate to investigate them, and starts blaming them that we are being subjected to vendetta politics. Let us understand that this case has nothing to do with the BJP. It started, as you said, on the back of a private complaint when the UPA was in power. At that time, the Metropolitan Magistrate took cognizance of the private complaint, ordered for an FIR, and that FIR basically dealt with the criminal aspect, that is the usurping of this entire money or this entire beneficial interest in the property worth 2,000 crores, which was meant for freedom fighters, being taken over by a sham transaction where the Gandhis became the owners of the beneficial interest via cloak that they had used in the name of young Indians. Now that is the criminal aspect of it. From there stemmed the ED probe, because in the same order and in several orders, there was a mandate given that ED and IT should also prosecute this matter. Then the ED filed a complaint on the basis of which it took the investigation forward. Thereafter, we saw that court after court was approached by Congress. It got no relief, including in the reassessment order of the income tax. Now coming, why the legal need? After the charge sheet has been filed in April 2025, you would have known that in May 2025, a court, the Rouse Avenue Court, has said, and the special judge, I quote him, it's a classic case of money laundering via puppet company where Gandhis benefited. Even the money that was spent to take over the loan of the Congress party on AJL and to transfer the shares, that money also came from a shell company, Dotex. These are all facts.
Yes.
Now the requirement in law is that the ED, despite the fact that it has filed a charge sheet, under section 44 of the PMLA, is duty bound to file an FIR. And therefore, and this has been said in the Madanlal Chaudhary versus Vijay Madanlal Chaudhary versus Union of India case. So the parallel ED probe needs to be given a predicate offence which has been basically done. So nothing new has been done. This is just a legal fortification of what the ED is doing, which is separate from the criminal case. But in both these cases, mind you, the Congress has got no relief. It just has, we and you have PAN card, Aadhaar card, ration card, lawyer sahab has ration card and Wakalat card. Mr. Kapil Madan has a victimhood card. They will play that victimhood card all the time without getting any relief in court.
Okay, Mr. Kapil Madan has joined us, as has Ashish Dikshit, lawyer and legal expert. Before I throw it open to Mr. Madan, I would quickly want to get in Ashish Dikshit. Ashish Dikshit, is this belated action on part of ED because they realize they are only relying on a private complaint? They do not have any predicate offence FIR, something that Apex Court has frowned upon, and hence this belated action. Is that how you see it?
See, this action was required on the part of Enforcement Directorate. It was a statutory obligation for them to make this information available to the relevant police authorities. And yes, you may say that maybe it's little late, but this was something which had to be done. And I think as far as the complaints are concerned, if you'll see the FIR and the charge sheet which has been filed, the complaint which has been filed by the ED, it makes out a very, I must say, a serious offence, and the accused persons are going to have a very difficult time explaining these transactions.
Okay.
And if you see the offences which are alleged in the present FIR, they are in addition to the offences under the money laundering, and the only defence which they might have claimed when the matter would have come up before the court, that there is no predicate offence. Now, maybe belatedly, but the Enforcement Directorate has taken away this limited thing.
So, Kapil Madan, technicalities aside, yes, law is all about technicalities, and in the court of law, one might argue whether this is belated action, whether this will apply retrospectively. All of that legal argument aside, the fact remains that Enforcement Directorate found merit in Dr. Subramaniam Swamy's private complaint. They found merit in the charge that the entire Young India floating and giving them 99% equity and 7% including the Gandhis benefiting. Ultimately, it is all fraudulent transaction, or as the FIR claims, it's conspiracy, it's cheating, and it's illegal appropriation.
Aruna, let me begin by saying it's a classic case and it's a textbook example of, how agencies misuse the process of the law. And I'll give you a very, very quick timelines, and, I'll back myself with the hard facts and data. You would recall this entire controversy started in 2014, and since then, the agencies wants to keep the pot boiling. Now, if you have taken 10 odd years to file this FIR, that would mean only two things. A, your officers and your agency is incompetent. B, you wanted to use this, for a, political purposes. There cannot be any third reason why you will wait for 10 long years to get this registered. Now, let me give you a, legal perspective on this. We all know Ashish is here. He is a very renowned lawyer, practicing in the criminal side. And he would also agree with me that for an ED case, you need a predicate offense. Now, in this particular case, ED case was apparently instituted basis Mr. Swamy's
Private
complaint, which was
yes.
treated as a predicate offense. Now, this, after the new criminal codes that have come, that mandates that before the court takes cognizance of any offense, accused needs to be heard. And all these legal arguments were taken, and what I am told, if the media reports are correct, the ED code was supposed to take, pronounce order whether the court wants to finally take cognizance, or whether the court doesn't want to take cognizance. Now they realized that their case doesn't stand anywhere, and that's the reason why they suddenly wake up from their slumber.
Okay. Shehzad Poonawalla, the point...
try to, plant this information.
Right.
And, you just want to keep the pot boiling.
Okay, Shehzad Poonawalla, here's what Kapil Madan and the Congress are accusing Bharatiya Janata Party of, that you wanted to play politics with this case. Politically, like you have been saying, no court has given the Gandhis any relief. You wanted to underline this again and again before the electorate. That aside, legally speaking, you do not have, the Enforcement Directorate does not have enough, and that is why, to keep the political pot boiling, these cases are being filed. That's the charge against BJP and the government.
First of all, a legal expert who has no particular vested interest or bias has given you the position in law as to why this was a statutory requirement. And I'm sure that Mr. Ashish has no skin in the game politically. Secondly, Ashish and you, Arunima, both are saying that perhaps this action was a little belated. So if we are erring on the side of not vendetta, but on the side of delay. How can we be delaying also and how can we be vindictive also? भाई vindictive काम तो जल्दी में होता है. डिले का काम मतलब कि आपने उसको उस शिद्दत से परस्यू नहीं किया क्योंकि आपको कोई पॉलिटिकल पॉइंट स्कोर करना है. मींस जैसे जैसे तथ्य आते गए, जैसे जैसे वो सिचुएशन पैदा होती गई, वैसे वैसे कार्रवाई होती गई. Thirdly, after 2022, and I bow down to the knowledge that Ashish has in this matter because he's a practicing lawyer. As far as I know, that the position in law is that there can't be self-adjudication of predicates by ED, and therefore ED is duty bound, statutorily and constitutionally bound to register FIR so that there is a predicate offense. It bulletproofs the case on one hand, but it also gives the opportunity to the accused that the accused cannot come out tomorrow say that where is the cognizable offense.
Right.
So I don't understand what is being spoken of and why are they crying. The larger point is that भाई अरुणिमा 1 करोड़ मैं भी देने को तैयार हूँ, 2000 करोड़ के बेनिफिशियल इंटरेस्ट करवा दो. I mean 90 crore loan Congress gives to AJL that is taken over by YI where Sonia ji and Madam Rahul ji are there and then for some good reason the Congress wipes off the loan. So you should have wiped it off when it was with AJL.
Right, Kapil Madan, please respond to that. I mean, legally we'll know. Let me finish my question. Let me just finish my question. Legally, you will make your argument when the matter reaches the stage of cognizance and framing of charges and trial. Politically speaking, BJP has been asking you and your party again and again, if all was well, if this was political vendetta, if this was witch hunt, how come courts did not give you relief right at the stage where Dr. Subramaniam Swamy went to court?
No, so let me tell you, I mean, it's an elementary criminal law till the time accused court takes cognizance as per the old criminal regime, you didn't have any opportunity of being heard. Now this has changed after new BNSS that have come in last year. And now the law provides that before the court takes cognizance, you are being given an opportunity of being heard. And that is precisely what is pending before the, Rouse Avenue court. And the court was to, pronounce an order. And then you have, this development where suddenly...
No, but this FIR was lodged in October. Just one point of fact. Just one point of fact, Kapil Madan. You are saying that, this incident happened after the court refused to give its order on cognizance. I just want to point out the fact that the FIR dates to 3rd of October.
So no, what I am trying to tell here is that maybe they realize that their case doesn't stand or there is a difficulty in maintaining the position that the court should be taking cognizance and that's the reason why you have this new development. Otherwise, let me just tell you, the ED case rests on the predicate offense. As per them, predicate offense was Swami's case. Now, if that is enough, let the court take cognizance on that basis. What they will try to do is, they will, again, there is an, FIR that is registered. You will use the pendency of this FIR to further complicate and confuse the situation because you do not want an adjudication. Shehzad doesn't want an adjudication. So, just like, our Honorable Prime Minister keeps on shifting his dates. First, he said, in 2020, farmers' income will get doubled. Now he says planning commission gone. Now he says we will become developed in 2047. So he does not, or BJP does not want an adjudication. They don't want a trial to happen. They don't want to keep the pot boiling so that they get political mileage out of it.
Okay.
And just to remind Shehzad here, Shehzad said that, we can't be vindictive at the same time and we could not be delaying at the same time. Let me tell you, Shehzad, it shows your incompetence also. When I say you, I mean your agencies who are investigating the matter. And it also shows that, once your, incompetence has been put forth, you now want to, because you want to be vindictive and continue with your vindictive nature, you have...
I know Shehzad wants to respond, but very quickly, Ashish Dikshit, presuming, all these legal arguments that are being made, let's hypothetically assume that the private complainant, Dr. Subramaniam Swamy in this case, who was associated with the Bharatiya Janata Party, till very recently, he was one of the key leaders of the party. presuming that the private complainant at some stage withdraws the complaint. Does that mean that the entire ED investigation falls flat? The charge sheet that they have filed, the prosecution complaint, cannot be taken cognizance of? Is that the legal position which has now forced ED to try and look for an agency which has filed a predicate offence? Ashish Dikshit?
See, as on date, the complaint filed by Mr. Swamy has been, the cognizance order has been upheld by the Supreme Court also. What will happen in future, it's a difficult thing to ascertain, but yes, if he does withdraw his complaint because it's a private complaint, then the ED complaint will have no legs to stand on. And perhaps it is only, we don't want to get into the domain of speculation, but this FIR is a mandatory requirement. This information which has been shared by ED with the Delhi police is a statutory obligation on them, and this has been upheld by the Delhi High Court. Initially, it was an issue which was raised by the accused in ED cases and other cases, that ED is being a judge and jury in its own cause, because what they are doing, they are investigating an offense, and now in the absence of a predicate offense, they are generating a predicate offense by filing a complaint with the police authorities. The Delhi High Court has upheld this provision of law, and the information which has been given by the ED, this practice has been upheld. And to say that this is only to save that there is a predicate offense, as on date, the complaint by Mr. Swamy stands. The ED does not require any other complaint to embolden or substantiate their case further. Their case, as of now, on the stage of cognizance, is sufficient on the basis of Dr. Swamy's complaint.
Right. Shehzad Poonawalla, you were wanting to make a point when I interrupted. Please go ahead.
Yeah, again, let me answer the political and the legal answer. If this is being done as vendetta, then how incompetent are you? And I don't mean you by you, I mean your legal team, including Abhishek Singhvi, that 14 parties made a petition to Supreme Court saying that ED is a handmaiden of Modi and Amit Shah, ye humko pareshan karte hain, and yet you could not prove anything. And the Supreme Court told you, chalo, ab jaiye aage. So you should have gone, they should have probably hired Kapil Madan Sahab. Secondly, I just want to ask that, Madam Arunima, you asked Kapil ji, case Lalu social justice messiah. Let me complete. Lalu, who has been convicted 5 times, they say that he is messiah of social justice, anyay hua hai. So ye to conviction ke baad bhi nahi mante. Now again coming back to the legal point, and just quote 2 things. Supreme Court 2016. Delhi High Court 2016, allegations of cheating warrant full disclosure in the case of the Gandhis. High Court and Supreme Court both rejected the challenge to the reassessment order of the IT returns. And in 2016, the Supreme Court says all allegations of fraud and misappropriation cannot be brushed aside without a trial. Now this is court after court rejecting any relief to the Gandhis, पर हम खराब है because they want right to चोरी. जमीन चोरी का अधिकार चाहिए और कार्रवाई हो तो ये अत्याचार बोलेंगे. ये इनका शिष्टाचार बन चुका है. They want right to loot. Can you believe? जमीन चोरी. This is case of जमीन चोरी. Vote चोरी didn't happen. जमीन चोरी is happening.
Kapil Madan, when you respond to that, also tell me, today you have a problem with the ED and the mechanism that ED has enforced, but under the PMLA, the kind of power that ED enjoys today was given when your colleagues from the party, when Mr. Chidambaram was at the helm of affairs, it was the UPA which decided that under PMLA, ED must be strengthened. Today you turn around and complain about vendetta.
Now, I can give you a brief history of PMLA. When PMLA was enacted, it only had, one schedule which had only 2 offences, which were grave offences, and not these kind of offences, which have been now being used as a vendetta politics. And Ashish is here. I mean, he knows history of PMLA more than me, and he would, agree with me. Now, the way, ED has now been used, because what we see in how many,
no, Kapil Madan, my question is very simple. My question is very simple. You are alleging victimhood. Just help us understand how.
I am giving you an answer. Initially, there was a schedule that had only heinous crimes that were made as a predicate offense. But what they have done after amendment, they have transposed all the other sections which were not there earlier. And that's the reason why when ED today ED can come into picture in any offense that has maybe a 420, which has 7 years of punishment, and ED offense has a punishment less than 7 years. But even in predicate offense you can get bail. but in ED offense you can't get bail. So these are all the legal technical issues which are still pending before the court of law.
No, okay,
Vijay
okay.
Madanlal is of course one judgment, but
Right.
there is review etc. pending, and you will
You
have
still
a
haven't
decision
answered
one
my
way or the other.
question. You still haven't answered my question. Answer my question, Kapil Madan. I'm just simplifying it for you. The charge that this FIR is making against Sonia Gandhi, Rahul Gandhi, Sam Pitroda, and others is that wrongfully, the entire 99% equity of AJL was wrongfully misappropriated in the name of Young Indian. There was a shell company that was floated. The party had no business giving a loan, and this entire transaction seems to be to benefit the Gandhis. Is there any direct counter to that?
No, I am sorry. I think this is all figment of imagination.
It's there in the FIR. We've just put out the FIR on your television
FIR
set.
says many things. You have FIRs day in and day out. The court ultimately after trial, what happened in 2G? Where they said, there is an allegation of, 200 crores. Today, where does that, 2G stand? Entire 2014 election was fought basis, the anti-corruption plan, and 2G was the premise of it.
Okay.
Now, what we saw, everyone got an acquittal in 2G. Everyone got an
Shehzad
acquittal.
Poonawala respond to
Please
that.
do not-
An FIR and a
please
charge
do
sheet
not.
doesn't have any value till the time
And
the
let me
court
tell you,
adjudicates.
Shehzad is also a qualified lawyer. He understands how criminal law, but I think political compulsion will not, make him speak on his, legal side. But we all understand and we all appreciate his political compulsion.
Yeah, he wants to speak. Go ahead, Shehzad.
Kapil, my dear friend Kapil, the kind of arguments you are making tonight, people will watch it and then all your clients will be lost. You are contradicting yourself. On the one hand, you are saying that the same courts of law, if there is no substance, will give you relief. And on the other hand, you are unable to explain that if this FIR is so totally baseless, why can't you go and take the same relief? And many of your colleagues have got the same relief. And let me again put it in the legal terms, because today, Arunima, the entire debate is just a legal procedural one. But kya isko mahol bana diya hai Congress ne subah se? Let me just tell you what the Supreme Court has said. A criminal conspiracy alone is not a standalone predicate. It must tie to a schedule offence via FIR. PMLA jurisdiction under Section 44 requires schedule offence FIR to align with the special courts area. These are in 2023, 2024, these are courts of law requiring the ED to do this. And when we follow the courts of law, and the most transparent manner, the most accountable manner these agencies are working with 95-97% conviction rate. Here you have Kapilji saying, don't listen to the Supreme Court. Chalao case aise, bina FIR ke chalao.
Kapil Madan wants
I
to
have never
respond.
heard such kind of argument.
So I really appreciate Shehzad being so honest and brutal in exposing his own government, because he realizes that there has to be an FIR in predicate offence, and they forgot to register that FIR for 10 years. Now when the court is analyzing, doing this, hold on, Shehzad, hold on. I understand, I appreciate your honesty and your integrity while exposing your own government, but nevertheless, let me just say, I think Shehzad has rightly said that there has to be an FIR. It took them 10 years to register the FIR. Can you believe it? Can you believe it?
Then how are you vindictive?
They try national. So I again, I would, like to thank Shehzad for being so honest and so candid on the show. And, perhaps, I don't know, on the legal side, he has taken, the right stand on the legal side, and he has, not clinched on his political side in exposing his own government. So let me also tell you, this has happened only because you have an situation where you will soon have an order on, cognizance, and it might go against them because of this reason.
Okay.
And that's the reason why you will have, this another, twist wherein there is another, FIR that gets registered.
Okay, Ashish
And let me
Dixit.
also tell you another thing. Let me also tell you, there cannot be two FIRs basis the same set of facts for the same offence.
So
Let me tell you,
that's
this
why
is
Ashish
also a
Dixit,
second
I began
There
by
are no
asking
two
you
FIRs.
if there is any new development that ED will have to show or EOW will have to show if this FIR is registered on 3rd of October and the charge sheet was filed or the prosecution was complaint was filed way before that. Will there be any legal trouble for that? But I want to conclude this debate, Ashish Dixit, by giving you the final word. Political vendetta or is this law taking its own course? Where do you see this really heading? Should the Gandhi Parivar be prepared to file anticipatory bail now that this FIR is in place?
See, I'll be very candid as a lawyer. The Gandhi family is in a rigmarole now. There is multiple cases which have been out. This FIR is also there. They have to. My Kapil Madan is very hopeful that cognizance order will not be passed. But in ED cases, on the basis of material which has been placed on record, I have seen not even one case where the court has declined to take cognizance. So that may not be a correct position of law. But yes, the complaint of Mr. Swamy was sufficient for the court to take cognizance of this offence. That can be treated as a predicate offence. This new FIR does not give any new material for cognizance of the ED case.
Okay.
So I think this part is, I think, not required to be stated by Mr. Madan, that there was a requirement to file this FIR. As far as that complaint case is there, that is sufficient, and the cognizance could have been taken.
Okay, so 15th of December, when it is likely that the court will pronounce its order on ED's prosecution complaint cognizance part, it will be still in the middle of the winter session. Winter session of Parliament is still 19. So perhaps Shehzad and Kapil Madan will meet us once again then to tell us if this is law taking its own course, or as Kapil Madan is saying, this is political witch hunt. Ashish Dikshit, Kapil Madan, Shehzad Poonawalla, appreciate all of you joining us tonight and debating this further. It is very clear that the predicate offence ED wanted EOW, Delhi Police's EOW, to file was to strengthen its legal ground based on which its prosecution complaint could be taken forward. What will the court say? We'll keep an eye. Slipping into